Good morning, ladies and gentlemen. Today's lecture is regarding service matters, and the topic of the day is repatriation and lien with the parent department under Service Rules Section Order 7-A. When any person is appointed in a department, that department is to be considered as his parent department. And if a person after appointment in a department is borrowed by a department on deputation or otherwise, that department in the law is to be considered as borrowing department. If in the borrowing department there is any minor or major complaint of misconduct, corruption or anything like that, the borrowing department has no right to take disciplinary action and impose any major penalty like dismissal of service on that employee. But instead of doing that, under the law, the borrowing department is liable and bound to revert that employee back to the parent department. My name is Ghulam Sajjad Gopang. I am MBA Finance First Position Holder from IBA University of Sindh, Jamshoro. I am LLB First Position Holder from Quaid-e-Azam Law College, Nawabshah, Sindh. I am the first advocate Supreme Court in the history of Nawabshah Bar Association, Sindh. And I am the youngest advocate in the history of Supreme Court of Pakistan. I am having more than 1,000 cases pending at Supreme Court, Islamabad, and having more than 100 cases reported in PLD law books of Pakistan. My most famous cases are 2019 SCMR 2063 and the other one is PLD 2020 Supreme Court 293. My WhatsApp number is 03332682662. If you want to contact me, you can drop a message on my WhatsApp number. Let's start our lecture with the interpretation of Honorable Supreme Court, which can be considered the best one for defining any section of law. 2020 SCMR, page number 25 is the judgment. The Honorable Supreme Court of Pakistan has interpreted that plain reading of Rule 7-A of the Punjab Civil Servants Appointment and Conditions of Service Rules 1974 showed that the lien with the parent department could be retained for a maximum period of 3 years and could not be extended beyond such period. Neither the department nor the service tribunal has any power or jurisdiction to extend it. If the employee is appointed in a department which can be considered his parent department, and on deputation or otherwise any other department has sought the services of that employee, and after joining in the borrowing department there is any kind of complaint against that employee, the borrowing department is liable and bound under the law not to take any disciplinary action against that employee, but to revert him back and send his services back to that parent department, that we do not need the services of this employee due to negligence, due to misconduct or anything like that. What has happened in the last few years, that the deputation and the borrowing has been sought illegally, unlawfully, and on the basis of political grounds, that a person is appointed in a department which is to be considered as a simple department, not having extraordinary jurisdictions, although each and every department is important institution of the country. But to achieve illegal means, the employees have deliberately got themselves transferred from parent department to the borrowing department. And in that regard, when the government is changing, the policy is changing, the borrowing departments took strict legal actions and imposed major penalties like dismissal of service, and such judgments are being set aside by the Honorable High Courts, Service Tribunals and the Honorable Supreme Court, by myself as well. More than 100 cases I have won only on this ground of Section 7A in service tribunals and especially at Supreme Court. 2018 PLC CS 1129 Supreme Court Azad Jammu and Kashmir says that judgment of service tribunal is set aside and the department is directed to determine and give the right of lien, and not only the lien but the seniority of the employee at its original position as well. The serial number was 1 when that employee was transferred, deputed or sought. The borrowing department sought the services of the employee from the parent department. When he was reverted back to his parent department after 2-3 years, then the seniority of the employee was disturbed and he was placed at serial number 10. He challenged that judgment and it was observed by the Supreme Court Azad Jammu and Kashmir that if the employee is sent back to his parent department, his seniority should not be affected. 2010 PLC CS 1302. This is regarding repatriation, effect on lien, seniority and promotion. This was also employee was directed to be placed at serial number 1 from serial number 9 in the seniority list. Then the judgments of Honorable Supreme Court, 2009 SCMR 194, the appeal of the department was dismissed. The department challenged the judgment of the service tribunal on the ground that the department has right to impose major penalty of dismissal of service on that employee. The Honorable Supreme Court held that no, the parent department has the right to do anything like that. The borrowing department is bound under the law to revert that employee back to the parent department. Similarly, 2009 SCMR 1472 and 1996 SCMR 413 are the judgments in which Honorable Supreme Court has clarified this point. And then it has been observed that if according to authorities, employee was guilty of misconduct on all or any of the charges in the charge sheet, he could be repatriated back to his parent department and the appeal was allowed. In this regard, the appeal of the employee was allowed, and 1999 SCMR 1680 and 1992 SCMR 435 were referred in the judgment and relied as well. So another judgment, set of judgment that I am referring you, that number 1 is 2005 SCMR 716, number 2 is 2004 SCMR page number 67, then 2000 SCMR 656 and 2000 SCMR 1780 and 1996 SCMR 284 and PLD 1996 Supreme Court 193, and then 2004 PLCCS 1099, 1151 and then 2003 PLCCS 1357, the Honorable Supreme Court has categorically and clearly held that the borrowing department has no right to take any legal action against disciplinary action against that employee, but the job of the borrowing department in the light of any kind of serious allegation is only and only to repatriate and send him back, revert him back to the parent department, and that department will take any action.